The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, first case we'll call this morning is Alzani versus MBN, and Mr. McClanahan, we'll hear from you.
May I begin, Your Honor? Good morning, Your Honors. My name is Dirk McClanahan. I'm from the law firm McClanahan Powers. I'm here on behalf of the plaintiff, Mr. Aman Al-Jazani, and the appellant in this case. This case comes before this court following a dismissal at the motion to dismiss stage regarding an employment action regarding national origin. The primary focus of the appeal and of the issues in this court are related to a comparator analysis or similarly situated. That was the element that was attacked at the motion to dismiss and was ultimately granted. The first thing I wanted to draw Your Honor's attention to, I think is relevant for the analysis, is the stage of the litigation in which this occurred. This was, again, at the motion to dismiss stage, which is very early on. We cited to a number of cases in our brief that we believe stands for the state of the law in that situation, which is an employee is at a significant disadvantage at that stage of the litigation in terms of information control. And we believe that the amended complaint that was submitted—
I don't understand that. The plaintiff has full control of the complaint and alleges the facts, and we determine whether those facts state a plausible cause of action.
That is absolutely true, Your Honor, and I don't disagree with you on that. What I meant is information control. So, for example, we believe that the standard in this case for which was required in terms of what amount of—
But on that point, let me just follow up. I mean, particular here, we're talking about, I can see certain cases where some information may be difficult to obtain from a plaintiff, and we might take that into account. But here, your clients were terminated for tweets, right? Posts or social media posts, tweets, things like that?
Yes, Your Honor.
And you know, comparator, if they had done so, tweets, posts, and things wouldn't be something within the employer's control, correct?
To the extent that the employer would have control of them deleting it, they would not. But whether the employer would have taken action or—
Sure, what action that's something that might be the case, but at least in determining whether comparators have posted similar information, that's not something that's within the exclusive control of the employer any more than it is you or your client, right?
Yes, Your Honor.
Okay.
I thought this case gets even more particular. You alleged that your client posted some tweets. The employer directed him to pull them down. He refused. And then somebody else told him to pull them down a day or two later, and he refused, and he was fired. And that's what the complaint says. And regardless of whether they had a policy, regardless of what the tweet said, he just refused to obey his employer's order. And I don't know why, how you can have a cause of action when you just flatly tell your employer, he's full of it, I'm not going to obey. I mean, the employer had its reasons, and he knew what the reasons were. He may have disagreed the effect of it, but he just clearly twice disobeyed a direct order to take him down, and he was fired responsively. It was not for a lot of other reasons. It was for disobedience, and I don't know where that gives you any kind of cause of action. He's an at-will employee, wasn't he?
He was an at-will employee, Your Honor. If I may respond to that, Your Honor, the pleading in the complaint does not indicate that he was terminated for disobedience. That may eventually be the position that the defendant takes, but the position that the basis he's given is that the postings violated the code.
Well, that's, yeah, we can go into that, and I don't know if it makes a bit of difference, but the complaint, I thought, made pretty clear that he refused twice and was therefore fired.
Well, Your Honor, if, again, one of the things I think is important about these postings are not part of his job. These are not postings required or mandated as a task or an employment effort. These are separate posts, as though any employee in any setting, whether they're a journalist or not, were to post on their own Facebook, social media. Then they said that because of that posting violated the code within the organization for purposes of unethical posting. Whether our client agrees or disagrees, or whether that is at an evidentiary level true or untrue, our position and what we've postulated in the complaint at the motion to dismiss stage is that it wasn't true, and that they were using that code.
All right, this is what you said in the complaint. This is what he said in the complaint. He said, shortly after plaintiff posted the tweet, Mr. L. Kalki called plaintiff and told him to delete the tweet. Plaintiff asked him to explain why Mr. Kalki did not provide a reason, so plaintiff did not delete the tweet. MBN thereafter suspended the plaintiff. That's for disobedience of that order. Second thing, you say plaintiff explained, this is a couple days later, plaintiff explained he would not delete the tweet because he did not understand what was wrong with its content. Defendant thereafter terminated plaintiff. Now, you don't think that those are two refusals to obey an order, and the adverse action was suspension and then termination?
I think the predicate to that conduct is the conduct that is at issue in the complaint.
It doesn't matter. We're talking about whether he disobeyed. He was fired because he disobeyed the order twice. The employer made a judgment. He could disagree with his employer, and they could talk about it. But to refuse to obey the order of the employer and then be suspended and then persist after his suspension to take it down, and he's fired. And that's what the complaint says, and I don't understand where this goes.
I think our position, Your Honor, is if the order to take down your posting that you posted privately outside of employment because it allegedly violates this code, and our position is that that allegation.
It doesn't matter whether it violates it or not. The employer took a position, and he disobeyed the order. He's at work. He's working for MBN.
Not when he makes the posting, Your Honor.
Well, sure he is.
He's
agreed to, I mean, there's no question about it. He's agreed to be neutral as a journalist, and that they had provisions. They say don't take positions. But regardless, we're not debating whether the code was properly violated or whether it's a good code. We're talking about a discrimination case. And the question is, did they discriminate because he was Iraqi? And the answer is, adverse action as alleged in the complaint was he disobeyed 2 orders.
The adverse action, respectfully, Your Honor, is that they're telling him to take down a social media post he made not while he was at work on the basis that it violated the code. He inquired about that. They told him to take it down, a private posting that he made outside of his employment that, as we've pled, doesn't violate the code. And the question is, then they terminate him as a result. So did they terminate him for a non-discriminatory purpose? Our position would be that that is absolutely
You know, a
discriminatory.
disagreement over violating the code is the employer's entitlement to make its determination as to what the code means, and it can enforce it. And when it tells this man, we believe that enforces it, take it down, and he says, I disagree, I refuse. And he gets suspended. And then they tell him a few days later, this violates our code, take it down, he disagrees, and they fire him. Now, we're not here to resolve whether the employer was right in interpreting its own code. We're here to determine whether that action, his firing, was because he was Iraqi, and there's nothing to suggest that. The suggestion in your complaint is that he was fired because he refused to take down the tweet.
Respectfully, Your Honor, I think the focus of the complaint is whether or not So for example, if they were to do the same situation to a non-Iraqi journalist, which we pled, and they don't find code violations for them, what's,
You have nobody who was warned twice, ordered twice, not warned, ordered twice to take something down and was retained. You have not alleged anybody in your complaint that fits that category.
and Your Honor, this gets back to the initial issue of information disparity. If that level of requirement is needed at the motion to dismiss stage, where we would have to know whether or not other employees have been admonished at the same level for purposes of a misconduct that led to our client's termination, that's
But that's
very.
your complaint. You're trying to allege that it wasn't because he violated the code, but they fired him not because he violated the code, they fired him because he was Iraqi. And the way you make that case, if that's your theory, is that you say other people who were not Iraqi had the same circumstances. They put it up, were told, and he refused to take it down, put it up, refused to take it down, that those persons were retained and not fired. Now, that's what you would have to allege. Now, if you can't allege it, that's what 12b-6 is all about.
Well, Your Honor, I think respectfully, our position is that that analysis is coming down too far down the rung. The assessment that we're trying to get the court to look at is, as soon as they start applying the code
But don't you have a problem there too? Like, even if we assume his insubordination all flows from the request to take down this tweet, and you want us to look at that, right?
Yes, Your
That
Honor.
that is your problem, that that's a code violation or not a code violation, and you think he's being singled out because he's Iraqi. But even there, the district court pointed out it's hard to draw a plausible inference that this was discriminatory because the complaint doesn't offer the comparators. And I think that's Judge Quattlebaum's point earlier, was that these tweets are available, for better or for worse. In your second case that you're going to argue next, you've put them in there, right? And the court could compare them. But here, there's nothing for the court to compare other than a vague, statement that other people did similar things and were treated differently, right? That's a conclusion, but there's no facts to back it up.
Well, so, thank you, Your Honor. I understand what you're saying. My response to that, for purposes of the complaint, is I think when we are getting to the point where we're doing line-by-line analysis, I think my understanding of and my read of the state of the law.
You think you can just say they're comparators because they posted similar stuff without telling us at all what the similar stuff is?
I think so to answer that question directly, Your Honor, I think the answer is generally yes with caveat, which is I think if you name someone in particular, you sort of hyper focusing on the person. I think if you say generally, like, there's other employees who make tweets, that's very broad. I would agree that is too nebulous. But if I say Miss Badai posts tweets, they're offensive and aggressive tweets, the need to have the exact content feels like an additional step that gets us into an evidentiary analysis of the language, which I think
Why
the
is that
Fourth Circuit
not?
has.
I mean, I think you'd agree that, the 12b-6 standard requires pleadings with enough specificity that they're not conclusory. You agree with that?
Yes, Your Honor.
Okay. Why is it not conclusory, even if you've identified a person, to say that they did similar stuff without giving us any more information than that?
I think if we're saying that that a particular individual has also posted inappropriate content, I think that is a fairly specific allegation, as opposed to, I mean, I think if you were describing another misconduct, like a fight at work, if you were saying he got into a fight with work, it'd be like, well, who did he get in a fight with? How many punches were thrown? What was the nature of the fight? Was it fisticuffs? Did he kick him at one point? Those levels of details are well beyond what is necessary to establish that this individual also got into a physical altercation at work. It was inappropriate, and they didn't get fired, and I did. And I think the same analysis is true here, is how deep do you have to go in terms of identifying? I think to the point where we're actually posting side-by-side content, the only benefit of that is to do an evidentiary analysis of whether or not it's sufficient. And I think for the purposes of the case, it's plausibility of
Right.
a claim as opposed to specificity of the claim, Your Honor. That's that's where I believe the court and I saw different at the proceeding. I have 35 seconds left, but I'll reserve for the remainder
All
of
right,
rebuttal
that's
if I may,
fine.
Your Honor.
Okay, we'll have you back on rebuttal. All right, Ms. Bagley?
May it please the court, Andrew Bagley from Kroll and Mooring on behalf of Middle East Broadcasting Networks. I think it'll be comfortable to the court if I mention them as MBN for simplicity's sake. MBN in this case, I think is facing a situation where it is dealing with a national origin discrimination case on behalf of an employee who's of Iraqi national origin. But please note that MBN is a company that you can tell from the complaint hires extensively from the Middle East. So a lot of the people are from the area. On the law, this case doesn't really push any boundaries. This is right down the middle of what comparators need to be. And we'll get to that in a moment. But Your Honors, what I think sets this case apart is that it's the complaint itself, the pleadings of the plaintiff, that explain the legitimate, non-discriminatory reason why he was terminated. The questions from the court have already pointed out the insubordination piece, and so I'm not going to repeat all of that. But I will just mention one more, and that is that plaintiff has mentioned the journalistic code as an entity, as a thing. There's more to it, and that is in fact at paragraph 28 of the complaint. And that's where MBN told its employees, stay away from Iraqi politics, because the situation in Iraq, I mean, this is a trip down memory lane where Iraq was the hot button in the Middle East, as opposed to where we are today. But what MBN said is, don't post about Iraq, specifically, and I'm going to quote from paragraph 28. They said, quote, stop posting any political content about Iraq on personal social media accounts. Well, it was not a week before plaintiff in this case did exactly that. And whether or not MBN interpreted the tweet correctly, it's undisputed from the complaint that MBN treated it as the tweet as an insult against the highest Shiite cleric in the world.
Counsel, can I ask you a kind of legal question? This is, this dismissal by the district court was analyzed under the McDonnell-Douglas test and the role of comparators in that burden-shifting test. Do we need to use that test? I mean, can't we just look at the text of the statute and ask whether there's any facts that plausibly allege discrimination based on national origin, circumstantial, direct, whatever, without, that utilization of that burden-shifting test?
Your Honor, you're raising an important point which goes to legal strategy of the defendant in this case, because I think what the statute would say, that you also have to establish that the plaintiff was an employee in good standing at the time of the termination. In other words, you don't even get to the comparator analysis if you can't even show that he was in good standing. And one would say that if you disregard insubordinate, if you're that in-your-face insubordinate, not only with your 2 levels up manager, but with executive management, you're not going to be in good standing. But I bring it up as a question of litigation strategy in that MBN decided not to rely on that in its motion to dismiss.
Well, I mean, maybe No, went with the McDonnell Douglas approach, and there's certainly law that says that. As I understand, that's a way of, discerning how the text operates that the Supreme Court put up in, a case. And my question might not have been clear, because I think comparator evidence would be evidence that a plaintiff could use if it was valid. I think direct evidence could be used if it was valid. I think any sort of circumstantial evidence. It just seems like, to me, you can resolve this case without McDonnell Douglas, and maybe you have a different view.
Well, Your Honor, the way the complaint was presented and the way it was set up with the extensive discussion of comparators, we thought it appropriate to meet them on that field.
Yeah, I'm not criticizing you for that at all. I'm just
Well,
asking.
the district court seemed to get hung into McDonnell Douglas, and maybe it was error for it to do it.
Well, Your
In other
Honor,
words, a comparator, you can make comparator allegations without doing the McDonnell Douglas burden shifting propositions. The statute says a person who discriminates on account of national origin violates the law. And one way you can show that is that they treated an Iraqi in one manner and treated somebody else in a different manner. And it's not a burden shifting issue, it's an allegation, it's a complaint, but the district court went down the whole McDonnell Douglas range, and I'm not sure that was, I think Judge Quattlebaum is raising a very serious legal point that's on a 12b6 or summary judgment motions, whether we ever get involved as McDonnell Douglas.
well, in fairness, Your Honor, I have not analyzed a straight-up statutory review of the word discriminate, for example, and the case law on, for example, direct discrimination, to determine whether the facts in the complaint, which to me are so obviously setting out the reason for the termination. In fairness, we did not engage in that analysis.
Thank you.
Based on the argument to date, I really don't have very much to say more than that, but I would be happy to answer any other questions that the court may have.
All right, thank you, Ms. Pack. Ms. Ambrose? Are you up?
I would be, Your Honor, if there are questions specifically as to comparators, which is my role, but if not, I don't need to take the time.
All right, very well. Mr. McClanahan?
Good morning again, Your Honors, and I don't want to waste your time by speaking just to speak, so I'll try to address just an additional item. Although it looks like the court is viewing some of the structure of the claim in a different way than probably I would like to use. One of the things I did think that came up and appeared to be an issue in the case was whether or not they had to have the same supervisor and the relevant factor analysis. And I think one of when I came in here today and what I was thinking was...
I don't think there's any formula for setting up a comparator to try to demonstrate that your client was treated differently. I think what you have to allege is enough facts on which you can plausibly conclude that one person was treated differently from the other. Now, whether it's the same employer or whatever, but the question is, you can't just say in your complaint, A was treated differently from the others and leave it at that. They had the same jobs and everything, they had that. Really what we're talking about, here's a man that was fired because he didn't take down a tweet that the employer thought related to the Iraqi circumstance. And you want to try to demonstrate that that was because he was Iraqi. Well, the way you would demonstrate that, and that you chose to do that, and that's fine, is to say others in a similar situation who put up posts about Iraqi were not terminated in similar circumstances. And you could even go further and say, indeed, they were warned, but they were not fired. But I don't see any of that in the complaint. As a matter of fact, your next complaint goes into more detail, but the question is, how do we determine whether you've alleged enough facts that plausibly alleges a cause of action for discrimination as opposed to insubordination?
So, Your Honor, if I may, I appreciate your initial point, so I'll just go through them as quickly as I can. Because I was concerned that the underlying court was focusing on that, oh, it's got to have a supervisor. I agree. I think the law is clear that that is not original analysis. I really like the quotes that we put in the brief, because I think those courts did an excellent job articulating what I think is the correct legal standard, which you've just, I think, identified.
Judge Brinkema in the next case, right, she agreed with you on the supervisor analysis, right? That what matters is who's enforcing the code. Is that right?
I think that was part of her analysis.
They had a
yeah.
different view on that.
But I agree with, and as it relates to one of the issues, in Your Honor, and I don't, as a plaintiff's lawyer I do both types, but I say the lens more through plaintiff because I tend to be more plaintiff than defendant on these employment cases. One of the allegations you were just asking counsel about is, well, do you have to go McDonnell Douglas? Well, no, you can prove discrimination through direct circumstantial evidence, or you can prove it through McDonnell Douglas.
And in complaint, you don't need to allege the burdens of proof at trial. As a matter of fact, the Supreme Court's directed us not to. And in Cleary-Evans, we pointed out that we don't do the McDonnell Douglas, we go to the statute. The question is, a plausible claim would be a plausible claim under Title VII. And so the question is, have you fulfilled the elements, plausibly shown that you fulfilled the elements of a Title VII claim? And that's the 12b6 standard, isn't it? The sufficiency of the complaint?
That is the standard, Your Honor.
Yeah.
I think one of the things we pled that was the court did not like in either of the first two, but one of the arguments we actually open up with is there's a direct discrimination claim here, which is we didn't violate the code. So even if we're not comparing to anyone else, this allegation that we violated a code by, and I think Mr. Al-Jazani's is the most straightforward, and that tweet without any framework is an innocuous statement.
But it's not, I mean, you've also pleaded that there was a direct verbal warning, do not post about Iraqi politics, right? So whether that's the code or not, that was the instruction, right? And that's the instruction that was violated.
But I think our position is that that is a discriminatory instruction. If I was an American abroad and they said, hey, do not post about America, on whether it's good, bad, and different, the standard is don't post against the code. Not
Well,
don't.
I mean, that's your argument, and yeah, one might say that's right, but one might say that if everyone is instructed not to post about America, that's not a discrimination on national origin just because it encompasses Americans as well.
And I'm over my time. My only comment would be that these are Iraqis, so that doing journalism about Iraq and the notion that they can't speak about their own country that's going through incredible political issues because we don't want you talking about Iraq is, I think, part of the entire framework of this discrimination. I'm sorry, Your Honor, for going over my time.
Thank you. The next case is Isaac versus MBN, and it is a parallel case. We have the same counsel. We normally come down and greet counsel. We're going to come down and greet counsel, but let's do it after the second case. So we don't need to greet you twice, although that might be a nice thing to do. So if it's okay with you, we'll begin with the next case, and with the same counsel. You can come and now address the second case, which is Isaac versus MBN.
Good morning, Your Honors. I've never had a case.
Good to see you.
I've never had a case.
You can begin anew. We're fresh. We give a fresh look at every case.
Okay, I appreciate it, Your Honor.
And we had a different district judge, didn't we?
Yes, Your Honors. In the first case, we had Judge Alston.
Different complaint.
Second case, we had Judge Brinkema. Different complaints, many of the same issues. Again, my name is Dirk McClanahan. I'm from the law firm McClanahan Powers here on behalf of the plaintiff, Your Honor. The case was dismissed in a similar posture. I think one of the things that stands out to me from Isaac when looking at Al-Jazani and even understanding some of the court's remarks is Isaac's case we built a little bit off of the second dismissal from Judge Alston and his commentary, and in my humble opinion, is far more robust in terms of just putting in, if they want, all of the facts that we could put in terms of having the actual postings. And I think a lot of the issues that I kind of understand the court to have raised with Al-Jazani, and I've never had cases back to back like that before, so I'm not sure if I'm supposed to talk about the other case or not mention it. But
Well, I'm not sure it helps you too much. In other words, I think it'd be cleaner to, we have a different complaint here. We're talking about the second complaint, the amended complaint. And we have some attachments. You have attached the tweets and the code and so forth. And we also have a different district judge that analyzed it somewhat differently in my judgment. But it's a 12B6 motion. No, it's summary judgment, isn't it?
no, is it 12B6? Your Honor?
12B6, right. 12B6 motion. So we have some of the same principles, but I think there's enough different that you get the benefit of a clean slate.
Thank you, Your Honor.
Yeah.
So in the Isaac case, we got very much into the details about one of the facts I think is significant that came up, and again, it sounds like maybe beating an issue that isn't going to matter for this court, but one of the issues we raised specifically or identified was that in this case, we were very aware that the direct supervisor of Mr. Isaac actually didn't want to terminate him, had no input whatsoever, thought he was doing great, and that all of the issue to terminate based on the code came from above. The other thing that is different is in this case, there was no discussion as to, take it down or any, insubordination.
Well, they both had the verbal warning, right? So this, Isaac was also warned, stop posting about Iraqi politics. Now, he didn't, there wasn't the refusal, right? The insubordination, I refuse to take down these tweets. But he also received the verbal warning, stop tweeting about Iraqi politics. He tweets multiple times about Iraqi politics, and he's fired. And in Judge Brinkema's view, if you were going to make a plausible case that this was about national origin, you needed to show someone else who was violating that warning, tweeting about Iraqi politics, who wasn't fired, and they were of a different national origin.
This gets to a really interesting issue that I think exists both in Al-Jazani and in Isaac, which is the complaint as pled asserts kind of the state of the affair for purposes of the case, other than the attachments that, go one direction or another. In our complaints, we are taking the position, because this is what our clients were told, that they were terminated not for posting about Iraq, but they were terminated for violating the code. And I think that's an enormous distinction in this case. And it may be that the defendants end up ultimately
Well, I'm not
taking.
sure your complaint is fairly read that way. The code is there, and the code essentially wants the journalist to be neutral on political affairs for good reasons. MBN wants credibility, and they have an audience, and the audience has mixed politics and so forth. And so they want the journalists to stay out of that. That's the code generally. But in this case, it involves specifically the Iraq situation, and there was a specific, management specifically warned not to comment about Iraq. Iraq was a hotbed. The Pope had just visited there. This was controversial. There's a question about the theocracy versus a non-theocracy, the role of the Pope, the role of the cleric and so forth. And the idea of a journalist getting involved and making comments about that 4 times after being told not to put up anything about Iraq, it seems to me if you were management, it's a pretty logical thing. We just can't put up with that. It's pretty clear he understood what he was supposed to do. I mean, your complaint's pretty fulsome. I mean, it tells the full story.
And we tried to be,
Yeah,
put it all, we weren't trying to sneak
Sure.
anything through, and that's never been my style. But
But even, I'm sorry, you were going to answer just.
No, Your Honor, please.
No, that's, I'll let you do that, then I'll have a follow-up.
I think the court's and Judge Brinkema as well was very focused on that particular fact. When we added that complaint and how I see it and how I would argue it to a jury, is that is the impetus of the entire problem in this case, is the employer cannot direct a distinction between, we don't talk about Iraq, we don't talk about America, we don't talk
Well,
about.
that might be the problem. What are the facts alleged in the complaint that lead to the plausible inference that this policy, don't post about Iraqi politics, that seems to be what you're saying now, that the policy itself discriminated on the basis of national origin.
Right, I think these are all intertwined
But like, what are the
issues.
facts that lead to that plausible inference? That this was a discriminatory policy, not based on any legitimate reason?
Because the basis of termination that they give is that it's a code violation. Because saying you can't post about your own country is clearly an improper instruction. And that's why I think when they
Well,
first.
I don't understand that. If you're a journalist and you start making, on your private commentary, you start making, taking positions on one side or the other that's critical of a government official, or calls the sheikh ghostly, or whatever, these things that he was doing in these tweets, it seems to me it just undermines the legitimacy of the whole network.
Well, Your Honor, you if I'm gonna split hairs on a word you used, which is you're a journalist, and that to me is I think a distinction that I would argue is not meaningful.
But isn't that the employer's decision to make?
I guess the question would be, could I tell my associates, when you post privately, do not post about anything related to the United States? Do not post anything about your home country when you're posting. And I give it to all my employees, whether they're from that jurisdiction or not. That is clearly, there's no basis to do that.
But there may be no basis to do it, but that doesn't mean it's discrimination on national origin, right? I mean, that may be someone may think that's a crazy policy, and someone may think that infringes on their First Amendment rights or something like that. But to say it's a discrimination on the basis of national origin, not to give an instruction to people from the United States and people from other countries not to post about, United States employees, I don't see how that makes it a national origin issue.
Can I reframe it through hyperbole a little bit? Let's say we change the narrative from national origin, which doesn't set off everyone's pings the same way. But let's say I wrote to an employee and say, hey, we don't want anyone posting about any women's rights. Like, I don't want to hear about women's rights. I don't want to talk about women's rights. We don't mention it. All my associates, we're not journalists, doesn't matter who we are.
Right.
Don't post about black people, don't post about that. I'm giving you some instruction about an identity,
Yeah.
and that's the sole basis. I think we would all recoil at that notion. Just because they said it's Iraqi and it's national origin, I think makes
But,
it
I
no
mean,
different. They're all the same.
To be fair, though, the policy the instruction wasn't don't post about Iraqis. It was don't post about politics in this particular country. I mean, and you give an example of the Chinese political situation, Tawila, who I assume is, from your allegations, is not a Chinese national, but this employee posted about or said things in an interview about Chinese politics and got reprimanded, right? They got suspended for 2 weeks. Now, it wasn't the same verbal warning, right? It was a bigger punishment. But that seems to suggest that it's not a targeting of a particular nationality or a particular, don't talk about this one country at all.
So I think I hear what you're saying, Your Honor. I think one of the distinctions that I make in this, and one of the hard parts that I have, and maybe I'm too locked in on it and I'm trying to pull myself back, but the NBN code is an ethics code, and if we're this is where I think at the motion to dismiss stage, I think maybe these are arguments that maybe we lose on this at motions for summary judgment. Maybe the facts as they come out are against us, but to say that their position matters as journalists versus anyone else, and to say that they're Iraqis in the type of content, and that we're drilling down to because it was Iraqi politics versus I feel like at the motion to dismiss stage, we're getting very granular in the comparator assessment, which I think is more appropriate at a later stage because we'll have more information. I don't have the job duties or I had to scrounge to try to get the job descriptions I could get my hands on to try to show who was similar because I was getting pushback on relationship. And I think at the end of the day, if we're looking at these NBN posts, there's some of the Trump tweets that I put in there, and whatever side of that line you fall on, it doesn't matter. Clearly, for purposes of the NBN code, they're objectively flagrant. And they are posted with impunity repeatedly. And the NBN code doesn't say Iraqi. If it said Iraqi in the NBN code, I would have been attacking the fact that it said Iraqi in the NBN code. But the NBN code just says journalists should be unbiased, impartial, give true statements.
But you alleged that there was a specific instruction with respect to Iraq, which is logical because Iraq was a hotspot at the time, and there was a specific instruction saying don't post about Iraq, right? That was in March.
There was a comment from, I don't have it right here, but the lines are the same. There was a comment about it,
Yeah.
which is why I didn't want to, I wasn't trying to,
It was an instruction.
Right.
And it was in violation of that position. I didn't understand you to be alleging in your complaint that the policy with respect to not posting Iraqi politics was itself discriminatory. I thought your argument was that the way they applied the code and its enforcement against the Iraqi politics against your client was discriminatory.
so I apologize if we inarticulately identified. What we're trying to show is that the comments and focusing on the fact that they're Iraqi is discriminatory. That's the problem. And then the application
Well,
is.
that attacks the code itself. In other words, they applied the code with greater force because of the hotspot in Iraqi, basically saying, don't comment about Iraqi. I mean, especially that's when the Pope went to visit at that very point in time, and they were basically telling employees, don't post about Iraqi. And that was what they directed, but you have not alleged, have you, that the policy itself was discriminatory?
Other than the comments that we haven't, I don't have the complaint right here. Unfortunately, I only walked up here with the one brief, but I think this was maybe the district court misunderstood us as well, the district court misunderstood us as well, because part of the arguments that we made was that there's a direct discrimination as well as the McDonnell-Douglas burden shifting analysis. And but part of our whole position is that they shouldn't be isolating about Iraqi. And I understand the court's position, and maybe there's a fight to be had, and a jury could be convinced that, hey, Iraqi's such a hotbed. I would also say Lebanon is in a constant state of war. All of these countries are in a constant state of war. And with Isaac specifically, different than Al-Jazani, is Al-Jazani makes the post immediately after the Pope visits. The issue with Isaac is he contends that at the termination, they don't even tell him what the posting problems are. They don't even say, like, hey, it's these 3 postings. That only appears for the first time during the EEOC. So his position is even more strained than that because they're not even pointing him to the postings that are a violation according to his contentions. That only comes up afterwards. And those postings are sort of scattershot from different points in time. They're not like all posted within 3 days of each other and, hey, we just can't take it anymore. It's a scattershot of postings over a couple of months that they contend this was somehow the last straw, the one that we didn't tell you about. And so I think for that reason, at the motion to dismiss stage, he's identified numerous comparators, people who are subject to the code, people who are posting with impunity, that I think are flagrant violations. All of his postings, I humbly believe, are not violations. And I would argue that, and I would believe that they aren't. I think that the answer is.
Wasn't he commenting about the cleric in Iraq?
In the bloody Ayatollah, is that the comment you're making? He does make that comment.
And he talks about him looking ghostly?
That is the Al-Jazani. Al-Jazani refers to him as a ghostly figure.
So this one, what did he say he looked?
He criticized that they were entertaining the bloody Ayatollah, but
Yeah.
as we put in the complaint, to be fair, the bloody Ayatollah is on a terrorist watch list. This is a,
Well, it doesn't matter, he commented about it. I mean, the question is, it's pretty clear he was making a comment about public officials in Iraq.
he did make a comment about it, Your Honor.
Yeah. All right. We'll hear again from, well, I guess, Mr. Bagley, we're going to hear from you.
Thank you, Your Honor. May it please the court, Andrew Bagley, Crowell and Mooring for MBN. This case is, for obvious reasons, very similar indeed to the Al-Jazani case that we've just heard. But there are a couple of things that I want to point out in particular, given the slightly different phrasing and framing of the complaint that was presented to Judge Brinkema. The first thing that the court has already asked about is the MBN code. And so if we could take a very quick look at Joint Appendix 151, which is the code itself, and it talks about the social media policy generally. And it says, don't damage credibility of you as a journalist because this could undermine MBN's mission. I think it's a truism that MBN gets to decide what its mission is and
Well, but
determine what does and doesn't.
I'm not sure this saves them, but if a company a company might very well have a good reason for saying don't post about Iraq political matters at a particular time. But you know, if your concern is that personal posts generally about political matters undermine, you know, the news outlet's credibility, what about the argument that you're allowing posts and commentary about political matters in other countries but not Iraq? That's what your colleagues suggest may be an issue. What's your response to that?
My response is that when you look at the countries covered by MBN's mission in 2021, Iraq stands out, and it is its own hotbed, and it's its own source of problems from a foreign policy of the United States. And as such, the guidance, to pick up on what you said, Judge Rushing, is not don't post about your life, don't post about international affairs generally. It's just don't post about Iraqi politics. Things are explosive right now. And it is not a term and condition, a protected term and condition of employment to post about Iraq. It's not a big,
And
it's
that
about Iraqi politics.
That admonition applied to Iraqi employees and non-Iraqi employees as well?
Absolutely. And that's why, at the end of the day, MBN gets to decide what its mission is, what it needs to protect itself, its credibility online, the safety of its people in Iraq and elsewhere. And so they place a limit on social media for purposes of Iraqi politics. That's a very small limitation. And I don't think it smells of discrimination because they can tweet about anything else they want. And this is what's so interesting in this case for Mr. Isaac. Judge Brinkema, upon the first dismissal of the case, said, you need to tell us more specifically what the tweets at issue were that Mr. Isaac posted in the wake of this warning not to do it. And in fact, that ends up being the only amendment to the complaint between the original and the amended complaint in this case. It's 9 paragraphs, starting at paragraph 80, and it lays out, in Mr. Isaac's own words, what his tweets were about. Your Honors, let's take a look at paragraph 83, Joint Appendix 142. Plaintiff explains that one of his tweets concerns a, quote, controversial speech, unquote, by an Iraqi person, quote, sanctioned by the U.S. for terrorism. Okay, why would you post such a thing if you've been told to stay away from Iraqi hotbed issues? At paragraph 84, again, the plaintiff advances in his own complaint what it is that he said in the tweet. And he talks about the prosecution of a high-profile figure in Iraq and pointing out, quote, elected official was meeting with a criminally accused figure. Come on. Paragraph 85, Joint Appendix 143, he talks about the book that was mentioned earlier today, the book discussing violence against U.S. troops. And lastly, in paragraph 86, Joint Appendix 143, he talks about a public figure, quote, employed at the time by a government institution in Iraq. I mean, how close does it have to get to politics and government function in Iraq, which you've been told not to do? Your Honor, the complaint itself is the plaintiff telling the court why he got fired. And then the last thing I'll mention before inviting the court's questions, if I may, is that there's one thing that all of these things have in common. That the comparators that have been advanced in the complaint have in common. Not one of them is alleged to have tweeted about Iraq. Not one of them is alleged to have said things that basically go directly against directive.
Does MBN broadcast only in the Near East?
It broadcasts, this is a more difficult question, and forgive me for giving you the long version. At the time, there was television, both throughout the Middle East and North Africa, what they call the MENA region, which covers all the Northern Africa and the Middle East. Then there was a separate television station, TV Iraq, that was specifically geared at Iraq. There are radio stations that go to the entire region. The Trump administration, the second time around, through the U.S. Agency for Global Media, has sought to drastically reduce the scope of MBN, along with its sister companies, Radio Free Asia, Radio Free Europe, Voice of America, which is much in the news, with Kerry Lake, basically trying to take a hatchet at the companies. And so it is now much smaller. And to answer your question today, the scope of its broadcasting is much smaller, but it goes throughout the region, yes.
I was interested more at the time.
At the time, yes.
Yeah,
Television
yeah.
had a specific Iraq television channel and a Al-Hurra Iraq and a television station that went to other countries in the region. And the reality is that MBN also has a lot of staff located in those countries. And so there's an element to bring this back to...
That's not in the record, though. I mean, you're talking about stuff out there outside the record now.
I think yes, that's absolutely
I mean,
right.
that's a little bit dangerous for you, right? I mean, you're talking about stuff out the record and want us to decide something on the complaint?
No, absolutely, Your Honor. I would only mention that when it comes to social media policy, when it comes to the MBN code and interpreting the code, the fact that the operations are throughout the region, even if that's outside the record, I think the court can take judicial notice of the fact that that exists. There's a reason for the safety, the elements that go into these policy statements do include the safety of personnel.
Yeah,
And so, at the end of the day, I don't think I'm not going to repeat much else that you've already seen in our briefs and heard this morning, but if the court has other questions, of course, I'm happy to respond.
All right, thank you. And Ms. Ambrose, are you in on the same position, right?
Yes, Your Honor. If you have
Okay.
questions, otherwise I'll...
All right, thank you very much. All right, Mr. McClanahan, we'll hear your rebuttal.
Thank you again, Your Honors. I'm sure you're getting your fill of having heard me at this stage. But I'll just address some of the points and comments that Mr. Bagley made, if I may, briefly. One of the comments was a statement that the company issued that proclamation about not talking or posting about Iraq to the company. Certainly that's not how the complaint is pled, and that's not how I understand that directive to have been instituted. This wasn't like a company-wide email. This was a statement to 3 Iraqis. And I think that's a significant, again, as we were sort of building and seeing the case, how we structure it, as opposed to like some company-wide mandate. I think, or again, some embedding it in the NBN code. It's not. That's a completely separate item, at least as far as anything I was aware of.
Well, and your complaint says that these multiple Iraqi journalists were given a verbal warning to stop posting any political content about Iraq, which makes it sound like they had been doing it already. So it was targeted at them because they had already been posting.
Thank you.
Is that a fair inference?
I believe that's right, Your Honor. Again, the issue that I would also point out as counsel reads the content and commentary from the postings, the postings that are posted by Mr. Isaac, again, we added those as to Judge Brinkema's request because she wanted to frankly see what they were. But our position has always been, and our complaint alleges, that at the time of termination, they do not identify the postings in any way. They do not suggest anything to them about the postings. They just say, we're terminating you. There were postings. He inquires about the postings, and they won't identify what they were. That it comes up only afterwards.
Was that in the EEOC process that it came up?
Yes, Your Honor. Or at least that's with respect to the other side, they contend a different position, but that has been that has been the plaintiff's position. That's what was pled. And so, again, I think if we're looking at application of the code, Judge Brinkema focused on that comment about the verbal warning, and I think really wanted us to find a comparator, and the only comparator in her mind could be a comparator that absolutely sort of met that same equivalency, where there had somehow been a warning to them as well, and that they posted about Iraq. I think our position was that that was a very narrow. That would be you're almost shooting down the Death Star to get someone who meets that level of comparator. And I think one of the things we tried to show in the complaint and argued in the brief.
Well, if you allege that somehow the warning about Iraq is not connected to your termination, then you've almost got zero reason for discrimination. The question is, you have no comparators, you have no animus, you have no Iraqi connection, because that argument detaches. I mean, your complaint fairly stated says that he'd posted 4 postings about Iraq and was terminated because of that. That's what I think a fair reading of your complaint is. But if you're now arguing that allows a plausible claim based on the notion that those postings had nothing to do with his termination, and the warning had nothing to do with his termination, then you basically have, out of the blue, somebody coming and terminating him. And the question now is, where are your allegations that termination was based on his Iraqi background?
I think that gets back to that this is where we're doing a disparate treatment analysis, and that's kind of, I think, what largely in a lot of the cases that we get into start to trend into the McDonnell-Douglas analysis, because if it's
I'd like
directed.
to know about your complaint. What's the theory? In
Right,
other
so,
words,
I'm
we're
sorry.
talking about a story, a factual story, and that's what we're trying to get to.
So I think
I know you're saying that juries can find facts different from the complaint, but at a 12b6, we take the complaint and we read the facts as alleged and determine whether those facts allege a cause of action. But if you all of a sudden start eliminating your allegations, you have in there the fact that there were warnings about not posting. You have in there were 4 postings relating to Iraq. You have the fact that he was terminated, and you allege that his termination was because he was Iraqi. And now, if you want to say the complaint doesn't make enough connection to, then your allegation is totally irrelevant about the postings about Iraq, And your allegations about the 4 postings, adding those, is totally irrelevant. Basically, your complaint, we take that out, your complaint is that he was a journalist at MBM, and on a given date, he was fired for no reason.
I'm beyond my time, but if I may, with
Yes, please.
30 seconds,
Yeah,
just
I'd like
respond.
to hear your response, yeah.
So I think the distinction to me, Your Honor, is it has never mattered to us as the plaintiff and in the complaint as pled that the postings were about Iraq. The issue is that he is
You pled
Iraqi.
it. It's not a whether it makes it, I mean, we take the complaint as thing. Your motive about whether you thought it's important or not,
Our complaint is national origin because he's Iraqi. If
I
he had been
understand
posting,
that,
we would have.
that's not enough to state a cause of action.
We're saying that other non-Iraqis are posting, whether it's about Iraq or not. And they are being found to have violated the code and others aren't. And the sole distinction that we're showing in disparate treatment through all of the examples of all the people we have is that one's Iraqi and one's not. The content being about Iraq is a defense theory. That's not our theory was never predicated on the fact that our postings are about Iraq. Our postings, we are contending, are not relevant to the analysis because they don't care if it's relevant. They're only eliminating us because we're Iraqi individuals. And time again in the examples we use against non-Iraqi individuals who are clearly violating the code. Our guys are getting terminated for violating the code, they're not. What's the difference? The difference we contend is that we're Iraqi individuals.
Okay.
Thank you, Your Honor.
All right, we'll come down and greet counsel. We'll give you a double greeting for the double cases, and we'll take a short recess.
This honorable court will take a brief recess.
Be seated, please. Next case we'll hear is Mook versus Hall, and Mr. Schnetzler, we'll hear from you.
Good morning, Your Honor. May it please the court, Nathan Schnetzler on behalf of the appellant Andrew Hall. Your Honors, this case is before the court on the district court's denial of qualified immunity to Mr. Hall with respect to his former employee's claim of interference under the Family Medical Leave Act. The issue here today is really whether a poorly worded regulatory scheme can support clearly established law so as to eliminate the defense of qualified immunity. It is our position, Your Honors, that in November of 2021, when the events at issue in this case occurred, the law was clearly required a government employer, to provide an employee with a 7-day period to correct certain problems with an FMLA certification form. Those certain problems are whether the form was insufficient or whether the form was incomplete. In this case, that was not the issue that the employer had with the certification form that was provided by Mr. Mook. Rather, Mr. Hall had concerns about whether the form was authentic or not. To summarize very briefly the facts, the form that was provided to Mr. Hall had clearly been filled out by Mr. Mook himself when it said, there's a clear section that says it's supposed to be filled out by the healthcare provider. And in addition to that, the form was not signed by the actual physician that was treating Mr. Mook's mother, for whom he was trying to take FMLA leave. It was signed by a nurse ostensibly on behalf of the physician. And in turn, Mr. Hall's office reaches out to the physician's practice to determine whether or not the physician actually authorized the nurse to sign the document. When the physician's office responded that the physician had not seen the actual document and had not authorized the nurse to sign it, Mr. Hall ended up terminating Mr. Mook's employment.
Do we make anything of that? I mean, I understand your argument on the construction of the statute and want to hear about that in a little bit, but, you know, suppose one were to read these facts and say, you know, even as alleged by the defendant, you know, I mean, it seems like a pretty hasty employment termination, and maybe that's wrong. I'm just raising that. If they could be, you know, if given a form that's even been filled out maybe too much by the employer and given it to a nurse and the nurse signs it, anyway, just optically it looks like a pretty drastic response to that, even under maybe the worst light. Does that matter? I mean, probably not really before us. I think the basis is what the statute says or doesn't say, but anyway, I'm just raise that.
No, it is a good question, Judge Quattlebaum, and I think for purposes, if the case goes to trial, that absolutely is going to be an issue for the jury to decide. But since we're here under the collateral order doctrine on an interlocutory appeal on qualified immunity, the facts really aren't at issue based on the parties' positions, and really it's a pure question of law about whether or not these regulations clearly establish a correction or cure period if a form is considered to be inauthentic by the employer.
Can I ask you about that? If we, hypothetically, if we agreed with you that it's not clearly established that the employer had to go through this process that the district court says, then we would remand for the district court to apply qualified immunity, right, to grant your client immunity. But isn't there a logically antecedent question of whether qualified immunity even applies in the FMLA context?
That has certainly been raised by the appellee on appeal for the first time. At the district court level, Mr. Mook conceded that qualified immunity applied to the FMLA. And so I think that
it's definitely waived. But, you know, courts often address a logically antecedent legal question. You know, the hypothesis is the parties can't, you know, agree on incorrect legal premises, right? And that we have to confront them. So, you know, can we confront it? I think we can. What's your position or your argument on that?
Our position that, since it wasn't raised below, if that question needs to be addressed, it ought to be addressed by the district court in the first instance.
That's a legal question. There's nothing really facty about it, and we're here on qualified immunity. It's the only way you got in the door, so it seems like we can answer it just as well, can't we? You addressed it in your brief.
We addressed it in our brief, yes, and Judge Rushing, this panel absolutely can address it, I think. And that's because, as we've noted, that other circuit courts have applied it. District courts within the Fourth Circuit have applied qualified immunity to the FMLA. And so.
Do you need, just to follow up on that, and I want to let you, do you contend that at present there's anything lacking other than a first instance district court take on the issue that we need to decide that we don't have now? I mean, do you feel like you've been able to brief your position sufficiently?
I think we have briefed it sufficiently.
That's probably a loaded question because it makes it sound like you haven't done a good job. I didn't mean that. The first time you responded was on reply, and I just wanted to make sure, you know, that you didn't have an issue besides the fact that it hadn't been addressed by the district court first.
And Judge Quattlebaum, I would certainly appreciate additional time. Obviously, that argument was sent to us, and we were on our heels on trying to draft a reply brief to deal with a pretty substantial argument that went to this whole whether or not the FMLA, qualified immunity even applied to the statute. If the court were inclined to address that issue first and not assume, as the district court did, that it does apply, we would certainly appreciate the opportunity for additional briefing if that would be allowed. But I think as we've laid out in our reply brief, we do believe that qualified immunity is applicable to FMLA. It's been found qualified immunity is not limited just to Section 1983 claims. There are a number of decisions that have applied it in various other statutory contexts.
More importantly, the defense provided by the statute is an affirmative defense that would require trial on it, and qualified immunity is intended to protect the official from trial. And I don't know how any affirmative defense could, in a statute, could deny qualified immunity to a public official, forcing him to raise the qualified defense and try that issue.
And yes, Judge Niemeyer, that's what we point out. If Congress intended to abrogate qualified immunity, it should have specifically said so when it enacted the Family Medical Leave Act.
Well, is that the right analysis? The Supreme Court seemed to say, you know, first we ask whether the tradition of immunity is so rooted in the common law, right, that has been kind of adopted into this statutory scheme, and all the policy reasons support it. If we find all of that satisfied, then we would expect Congress to speak specifically if they're going to abrogate this great history and tradition of common law that has these immunities. So the Supreme Court goes through that analysis to determine that, all right, 1983 brought with it these immunities, and we'd expect Congress to speak clearly. But we have to go through that analysis first, right, to determine whether the FMLA brought with it, you know, when Congress enacted it, it had these traditional immunities that typically adhere to these sorts of claims, whether it had those in mind or not. We can't just jump to the conclusion that every single statute and every single cause of action gets immunity, and we expect Congress to speak clearly otherwise, right? So we have to start at the beginning of the analysis.
Well, and that's where I think particularly like perhaps in the Wyatt case from the Supreme Court that addresses this specifically, you know, one of the issues that I found that distinguishes Wyatt from the situation at hand was that Wyatt was looking at whether or not qualified immunity should apply to private parties. So, you know, you have a situation where private individuals certainly haven't been entitled to any sort of immunity in that context, in that case. And here, I think there is a very developed body of law that qualified immunity has been afforded to government officials acting in their discretion, and absent intentional or reckless conduct, that they've been entitled to assert that defense. And so I think.
Outside of 1983 and Bivens, is there a Supreme Court case that does that?
I can't think of one off the top of my head, Your Honor. I don't believe there was one cited in the briefing. So. If I may, I do just want to point out why, specifically, just so that the court's aware, why these regulations do not clearly establish this 7-day cure period for purposes of the authentication piece. And number one, I think, is just a basic principle that when an employer is presented with a document that appears perhaps may be false or has been submitted under false pretenses or whatever, authentication, handing it back to the employee and saying, I need you to have this authenticated by the physician, it doesn't really make much sense. And I think that the regulations really actually kind of identify that, because if you look at 29 CFR 825.305C and together with 825.307A, authentication is left out in several areas, and even more so, the regulations set out some specifics about clarification. So they even distinguish between clarification and authentication. I think that's because the regulations envision this situation where an employee is being asked to provide very private health information to an employer. And in order to protect that information, we don't want employers just going out and contacting someone's physician and getting that protected information. And so if the document is insufficient and they need additional information, that would, if the regs don't permit the employer to ask the physician for that. If it's incomplete, if there's a blank in the document, the regs don't permit an employer to go directly to the physician. And if there needs to be clarified, again, that's going to require additional information or a back and forth about the actual health conditions. And so authentication.
Well, text-wise, it seems to me you're doing the common sense analysis, but text-wise, it seems to me you seem to have a stronger argument, because in the C, section C, they refer to incompleteness and insufficiency, which is something that could be completed or made more clear, and that's what they say. And lower in that instruction, they refer to that as such deficiencies.
Yes, sir.
They use the word deficiencies for those because that's exactly what they are. On the next regulation, when it relates back, it says that you can only, you need to do it after the employer has given the employee an opportunity to cure any deficiencies as set forth in C. And the deficiencies are those two things. But that does not say that the authentication needs to go through that process. It's a time thing. It says after those deficiencies are cleared. Well, of course, in this case, there's no deficiency. As defined by this regulation, we only have an authentication issue. And so it doesn't need to go through the cure. But that, I think that's you're making it a common sense thing. But I think statutorily, the word deficiency is an important word, and they use it, define it in C, and then they refer to it in A, this next section that we're talking about. It may be ambiguous because it could be a manner as described, but it seemed to me it's more temporal because the substance of the word authenticate is not subject to cure. Authenticate is it's a false document.
Correct.
And so it doesn't quite make sense, but it says you can only address that after you've given the 7-day cure for any deficiency, and they use the word any deficiency, and any deficiency refers to the word deficiency, such deficiencies in the prior section, which are incompleteness and insufficiency. It seems to me that maybe the court might have gotten it wrong, or at least it's deeply ambiguous.
Absolutely, Judge Niemeyer. And then even one step further on the strict textual reading of it, the very last sentence of 825.307A, it says it's the employees is responsible to provide complete sufficient form and to clarify certification if necessary. Again, it leaves out this authentication piece because that's a totally separate animal. And particularly in a situation where the employee can't actually authenticate the document. I'm out of time. I'll reserve the rest of my time for
All right,
rebuttal.
thank you.
Thank you.
All right, Mr. Lehman?
Thank you, Your Honor. May it please the court. My name is Brian Lamon. I'm the director of William & Mary Law School's Appellate and Supreme Court Clinic, and it is my absolute pleasure this morning to introduce Jack Kardasha. He is a 3L who, under this court's Rule 46A, will be arguing today's case on behalf of the plaintiff appellee, Daniel Muck.
All right, thank you.
Thank you.
Professor. All right, Mr. Kardasha, welcome. Is this your first argument before a court?
It is, Your Honor.
Well, good, welcome, and you'll enjoy many more. We'll hear from you.
Thank you, Your Honor. May it please the court, Jack Kardasha on behalf of the appellee, Daniel Muck. We ask this court to dismiss this appeal for lack of jurisdiction or in the alternative to affirm the district court's summary judgment denial for 2 reasons. The first is that this court lacks jurisdiction over this appeal because qualified immunity may not be raised as a defense to Family and Medical Leave Act interference claims. And second, even if this court finds that qualified immunity is available as a defense, the Family and Medical Leave Act's regulations clearly establish an employee's right to a 7-day cure period for any deficiency in the employee's FMLA certification form.
So, counsel, if I could, if we could start with the first point. It seems to me on whether qualified immunity applies, there's maybe 2 questions. One is just, does it apply? Your argument on jurisdiction seems to be we can't even get to it because it doesn't apply, which feels kind of circular because we got to decide whether it applies before we could dismiss it for not having it apply. Seems like that's a pure legal question. It's not that different than whether law is clearly established. So, from a just jurisdictional standpoint, based on the nature of the question, I don't understand why we wouldn't have jurisdiction. Now, ultimately, if we were to take that question and address it, here in the first instance, we may or may not agree with you that there's no qualified immunity for a FLMA case. I'm having trouble understanding, why we don't have jurisdiction to even, answer that question.
So to the jurisdictional point, Your Honor, it's first our contention that for this court to have jurisdiction, first qualified immunity has to be available as a defense, and then the district court second must deny that qualified immunity defense, but because
Why does it have
here,
to be available? I mean, the district court denied qualified immunity because it wasn't, the right wasn't clearly established. And we have jurisdiction to review a denial of qualified immunity to the extent it's based on a legal ground. Like we can review that interlocutory. So why can't we review that?
well, so it is our contention that this is a jurisdictional issue just because qualified immunity has to be available first as a defense. But even if this court finds that the availability of qualified
The
immunity.
district court could deny qualified immunity and say it's not available. But the cases seem to suggest if it denies qualified immunity, it's an interlocutory matter. And really that goes to the whole argument, is the whole reason for qualified immunity is that we have public officials doing the business of government, and they carry on their business, and they're being held liable personally for damages. It would discourage government service. And so when a government official says, I'm going to be held personally liable for damages, in this case, a good hunk of money, the question is then, did he violate a clearly established law that everybody in his position would know was a violation of the law? Now, the question I have is, in this case, it was denied, and so that official he's still exposed to the damages. And he certainly can appeal, and the reason for the interlocutory appeal is the immunity protects him from the trial itself. And so if we didn't take jurisdiction over those cases, simply because the district court said it's not available, then we would be denying the ability for that official to have us review that issue.
So we do agree, Your Honor, that if the district court had applied the Wyatt framework as we urge this court to adopt today, that the defendant would have the ability to appeal that decision to this court. But even if this court doesn't find that this issue is jurisdictional, it still can hear this issue. In Giannato, for example, this court did exercise its appellate jurisdiction to consider the availability of qualified immunity under the False Claims Act. And in that particular case, there is a very similar procedural history. The district court assumed that qualified immunity could be raised as a defense under the False Claims Act and denied a motion to dismiss on qualified immunity grounds. From there, the case was appealed to this court, and this court noted that the availability of qualified immunity is a threshold question that needed to be addressed despite the fact that it was not raised below. So even if this issue...
So that's a different issue than jurisdiction.
Yes.
In other words, you want to argue whether qualified immunity can be asserted. And that would be another ground to support the district court, but the official is exposed to these damages personally out of his own assets, and he doesn't want to go to trial on this if the law he was applying was sufficiently ambiguous that a person in his position wouldn't clearly know is established. I mean, in this case, we have no case law on which he would focus on, and yet you're asking him to be answerable to, what's the addendum in this case?
It's $500,000 in damages.
$500,000.
Yes, Your Honor.
And he's a public official, and you're going to hold him, he's going to lose his house and his car. I mean, it seems to me the whole purpose of qualified immunity is to encourage people to serve in the public service without that exposure, and unless they deliberately violate the law. So that you're arguing that because there's an affirmative defense in the statute, which he would have to prove, he has to then stand trial. In other words, somehow qualified immunity is avoided. I don't understand the reasoning at all of it mechanically, and I must say, if the whole purpose of qualified immunity is to give the man a chance to argue, I didn't know I was violating the law, and therefore I'm not going to be personally held for damages. You're arguing that, oh, he has to answer, we have an affirmative defense of good faith, and he has to go to trial, take depositions, and prove that. That's totally contrary to the whole notion that we're protecting public officials.
So that does take me, if the court does adopt the Wyatt framework here and looks to whether qualified immunity is available as a threshold matter, that takes me into the second part of the Wyatt analysis itself, looks at whether there are strong reasons that support reading that qualified immunity defense into the Family and Medical Leave Act. And here we do contend that there...
Why do you have to read it into an act? You don't read, you read it into any liability. The reason for the immunity is not based on an act. The reason for the immunity is that a public official is going to be held personally liable for damages. And in this case, you're asking for $500,000 for this guy who might have made a bad judgment or not. And the question is, if he did it deliberately, he's responsible. That's what the purpose of qualified immunity is. It's not a balance between whether there's a good faith defense in the statutory claim and his personal liability. You're putting him to suit, which violates the immunity in and of itself.
The Supreme Court initially formulated a qualified immunity defense in Section 1983 litigation because Section...
It's all over. It's not just there. Qualified immunity is any public official who is being held liable for damages.
Are you aware, I asked your colleague about Supreme Court applying qualified immunity outside of the 1983 and Bivens context? I didn't see any cases where that had been done. Do you agree?
Yes, Your Honor. The Supreme Court specifically has only applied the Wyatt framework in Section 1983 cases themselves, but the Fifth Circuit did recently adopt the Wyatt framework in the context of the Fair Labor Standards Act.
Right.
So this would not be the first instance of this test applying to a federal statutory scheme outside of Section 1983.
Yeah, my point was really in terms, I mean, it was intended to, I think, be somewhat sympathetic to at least part of your argument that, you know, the notion that qualified immunity applies to all public officials regardless of the claims, you know, that may be the result, but we don't have the Supreme Court's application of it hasn't gone that far.
Well, and to the point that I was making with Judge Niemeyer's question earlier, the Supreme Court did initially formulate qualified immunity in Section 1983 specifically because that statute itself did not provide specific defenses
Right.
that were incorporated. But here, the Family Medical Leave Act is distinguishable because itself does provide a complete remedial scheme. It includes remedies for plaintiffs to assert, and it also provides for defenses that employers may raise.
And your position is not that those defenses equate to qualified immunity. They clearly don't. They only limit, some sort of damages. But your point is that Congress took the, if Congress engaged in a process of deciding remedies, that indicates they were engaged in it and elected what to include and what not to include, and that's indication they didn't intend for qualified immunity to apply when they've taken the time to consider what defenses might exist.
Yes, Your Honor, and that's the exact decision that the D.C. Circuit reached in Berry versus Funk, where it declined to read qualified immunity into the Electronic Communications Privacy Act.
But let me ask you this. I mean, you didn't raise it below. It comes up in the responsive brief. The defendant does address it. Judge Rushing mentions, I think, fairly that it's a legal issue that we can do, and you've indicated that we can do it. But at least it's a pretty big decision. There's not a case on it, I don't think, on this statute anywhere that I saw in the country from an appellate court, if I recall. So, and we've got one side only had a reply brief to deal with it. Why should we deal it now? Why shouldn't we deal with the issue that the district court ruled on, flag it as an important issue and send it back for the district court to do that?
So I'd point this court to the Fifth Circuit's decision in Stramaski versus Lawley, and there the court did excuse a potential forfeiture issue to consider the availability of qualified immunity under the Fair Labor Standards Act. And there, the court itself had raised the issue for the first time on appeal. It was not raised by the parties, even in their own appellate briefing. But here, the crucial difference is that the issue was raised in our briefing on appeal, and then opposing counsel did have the opportunity to reply to that briefing as well and assert arguments to the contrary of our position. So it has been fully briefed to the point that this court can and should decide it today, rather than sending it back on remand. And so turning back to the Wyatt framework itself as well, a second reason to not read qualified immunity into this statute is that the Family Medical Leave Act enumerates a national and uniform standard for unpaid medical leave.
And you might be right about that, that the policy arguments are relevant, but isn't like the preliminary question, part of what you just said is a reason not to read this into the statute. So it's not in the statute, right? So we have to have some reason to think that Congress wanted an immunity it decided not to write in the statute, right? And in the 1983 context, the Supreme Court explained to us how the causes of action that were being brought, they look at the cause of action and analyze whether there have traditionally and historically been immunities that applied. And that gave the court reason to think that Congress meant to adopt all of that when it wrote the statute, right? But here we have to start at the beginning, right? What gives us reason to think Congress meant to incorporate immunities it chose not to write down in this statute?
So that does go to the first factor of the Wyatt framework, which is the analogous common law tort piece. And as our briefing details, we were unable to identify an analogous common law tort with that well-established history of immunity. And Hall similarly does not provide an analogous tort of his own that carries that history of immunity in the context of Family Medical Leave Act interference claims. And so there isn't that history of immunity that the Supreme Court did find in cases such as Pearson that justified permitting a qualified immunity defense in Section 1983. And importantly as well, Hall's briefing does assert that qualified immunity is the default unless Congress expressly abrogates it. But the Supreme Court's case law does state that it has only read qualified immunity into statutes when doing so has been supported by a history of immunity firmly rooted in the
Right,
common
but
law.
it brings the, we like to say things like it brings the old soil with it, right? That's the reason that the court has read these immunities in. It's not as though immunity exists and the judges get to just make up immunities willy-nilly, right? And so we have to look at the old soil here, which, it's maybe unsurprising you couldn't find any because that's in your interest not to find any. But your opponent also didn't, and I'm having a hard time coming up with something that would be analogous. This seems like kind of a new right that hadn't previously existed in a new framework, and there's no reason to think there's any old soil that's clinging to these roots.
And so, first, yes, we were not able to identify an analogous tort, but we did point out 3 in our briefing: wrongful discharge, retaliatory discharge, and tortious interference with the contract, that do come a little bit closer to being analogous, although we don't believe they are a good fit. But even then, looking beyond whether they're analogous into that history of immunity for those torts, we did not find case law that demonstrated that firmly rooted history of immunity for those 3 specific torts. And so without finding that analogous common law tort with the well-established history of immunity, that is sufficient alone under the Wyatt framework to not read qualified immunity into this statute before the court even gets into the strong reasons that could or could not support reading the defense into the Family Medical Leave
Right,
Act.
and in those policy arguments that in this context, you have public employees on both sides, right, of any employment claim. So there's a disincentive for the defendant to become a public employee because he's going to be personally liable, but then a disincentive for the plaintiff too, right, because he's stripped of, FMLA rights he would have if he were a private employee, if we're going to move to step 2 of Wyatt.
Right, and so that was earlier, and I was making the first point about one reason to not read qualified immunity into this statute is that it enumerates a complete remedial scheme. It provides both remedies and defenses that look after the interests of both employers and employees.
What's a policy of, we afford qualified immunity to officers who use allegedly excessive force
So
under the Fourth Amendment?
a response to that, Your Honor, would be that in Section 1983 cases, for example, where an officer is being sued for...
I'm talking about a federal officer.
Right, so in an instance of that instance is a public official performing functions that are inherent to their public office, different from that of a private actor. But here, under the Family Medical Leave Act, there isn't that distinction between public and private employers when they're...
And I didn't understand the difference of a police officer performing a service for the government is different from an attorney who represents the government?
So the difference, Your Honor, would be, for example, a police officer compared to maybe a private security guard or private prison guard.
I'm talking about, I'm saying, what's the policy? We have an attorney representing the government, and we don't give him immunity, but we give the officer who makes the arrest immunity.
So to clarify, the point I'm attempting to make is that the difference between a public employer and a private employer is not meaningful under this particular statute, because they're implementing employment functions that are essentially the same regardless of whether it's a state agency or a private company. And so reading qualified immunity into this statute would undermine that national and uniform standard for unpaid medical leave.
Except the purpose of immunity is not related to a particular statute enforcement. It's related to public service and the idea that we're holding public officials personally liable for damages.
Right, but doing so would create an uneven standard for unpaid medical leave, because it would permit public employers to raise a defense that is not similarly available to private employers, and it does impair a plaintiff's ability to recover damages in an instance here where we do allege that there was FMLA interference. And so that undermines the Act's purpose of creating that uniform and national standard.
Can we, you're getting close to the end of your time, and we've had a good discussion on the qualified immunity issue. I'm having more trouble with your issue, the theory that you violate the reg, much less that it was clearly established. Judge Niemeyer talked about the importance of the word deficiency. it seems to me that's a pretty compelling reason to talk about, clarification and authorization different than completeness and sufficiency. Even if there's a little ambiguity, there's at least a solid reading contrary to the way the district court read it seems to me. What's your position on that?
So first, I'd point the court to the words "any deficiency." Any means every, such that it includes all types of deficiencies.
But why is
And-
clarification and authenticate, I mean, it says any deficiencies as set forth. I mean, so that's the point. First of all, any deficiencies as set forth in the prior section. The prior section sets forth deficiencies in terms of completeness and sufficiency. And then in, 307, there's no description of clarification and authentication as a deficiency. Nowhere does the regs say those are deficiencies.
I see that my time has expired. May I briefly answer?
Sure.
So the word deficiency, even based on the definition provided by Hall, is lacking a necessary quality or element. And so here, a necessary element of an FMLA certification form is that the medical section is completed by the employee's doctor and not the employee, as it was in this case. And the words "as set forth in" incorporate the procedural aspects of Section 305C,
It
such that
says after, though, it puts a temporal aspect. After, it doesn't say in the manner of. It says you address the authentication after addressing the deficiencies in Section C. And in Section C, it specifically refers to those two aspects, incompletion and lack of clarity, as such deficiencies. And so the prior one says such deficiencies as set forth in A, and it says after those have been addressed. Now, in this case, of course, there were no such deficiencies. So that would leave the authentication, which is not a deficiency, it's a falsity.
So first, Your Honor, Hall suggests a reading of the regulation that suggests that it would be the deficiencies set forth in Section 305C, but it says any
It says
deficiency.
any in 305, but it says after. It doesn't say in the manner of handling it. It says after addressing the deficiencies in 305.
And just very briefly, I'd point the court to the Department of Labor's 2008 revisions to these regulations. And the department does discuss Section 307A, noting that it requires that employers permit employees to cure any deficiency, quote, pursuant to the procedures set forth in Section 305C, which demonstrates that Section 307A does require that 7-day cure period for all types of deficiencies. And so if,
Okay, I understand what you're saying.
and
Yeah.
if there are no further questions, we ask this court to dismiss this appeal for lack of jurisdiction, or in the alternative, to affirm the district court's summary judgment denial.
All right,
Thank you.
thank you very much. All right, Mr. Schnetzler?
Thank you, Your Honors. First, very quickly, with respect to the argument made by Mr. Kardashian as to the revisions, I think it's important to keep in mind as well that that language about, should ask the employee for permission to remedy anything about the form, that was excised completely. And then we're left with this sort of what I would say regulatory quagmire of language. And perhaps it's more clear as we've submitted, and Judge Niemeyer, as you suggested, but that language
How
was
would you-
taken out.
If it was fraudulent, if you had a fraudulent certification, how is that cured? Is there any cure to a fraudulent certification?
I don't think there is, and I think that gets to the heart of what this court has said in the Atkins case, is that it doesn't allow, an employee to, impunity to commit fraud on his employer.
In this case, it's probably not fraud, but he did write out and fill out what the doctor should have filled out. I know perhaps he says I was trying to save time or whatever,
Yeah.
but that was pretty false, and he deliberately did that. Now, maybe he gets some cover that he was going to present it to the doctor or whatever, but it seems to me the whole notion of authenticity is different from correcting an insufficiency, a deficiency.
I should make clear, that's a fair point. That was a hypothetical. Authenticity would include fraud, and I'm not suggesting that's what we have here. I was saying that was part of what would fall under there. Just
Correct, correct. And that really wasn't the position we took below.
Right,
But,
right.
Judge Rushing, if I could return back to your question during my opening with respect to, sort of addressing whether qualified immunity even applies and how we sort of wrestle with that in regard to what the Supreme Court said in Wyatt. First, I believe, or I want to make clear, I believe this court can assume without deciding this question, it can assume that qualified immunity applies just based on the posture we are here.
Yeah, is there something to be gained? I guess that's my question. Is there something to be gained by sending that question back to Judge Cullen and asking him in the first instance to analyze whether qualified immunity applies to the FMLA, and then if he decides it doesn't, taking a second interlocutory appeal to resolve it then? Or, and the answer, I'm not trying to suggest there's nothing to be gained, because you only got to address it in your reply, but is there something to be gained by that procedure?
No, I think it's inefficient, and because I think you're right, we'd be right back here having the same conversation, probably just a more focused on whether or not it applies. But I think the court has, in other contexts, assumed certain questions without deciding and reaching the issue that was actually presented.
Do you understand qualified immunity only be applying to state officials?
For purposes of the FMLA or just in general?
No, generally. The doctrine of qualified immunity, isn't it applied to
It
federal
applies to
officials?
federal as well. A Bivens action would be an example, I believe.
The whole law enforcement area.
Correct, Your Honor. And so I think the court can assume without deciding, specifically because other circuit courts of appeals have determined that, or stated that qualified immunity applies in the FMLA context.
They haven't really explained it, right? You had, like, your difference between determined that, stated that, like, they've given no explanation, right? They've just applied it on the assumption that qualified immunity applies to every law under the sun, it seems like.
Well, I don't think that they've taken that position, and I believe it's the Straminsky case that my colleague referenced. They actually specifically referenced, yes, we've decided it applies in the FMLA context, but we're not going to apply it in that context in that case. And I can't remember, I think that was an FLSA case. And of course, but the Eighth Circuit's also applied it as well in Sterling versus Board, and in Hager versus Arkansas Department of Health. And as I already mentioned, the Fifth Circuit has applied it.
So what about this situation? I don't know if it's more pragmatic than legal, but if we were to decide that issue, say there's no qualified immunity, hypothetically, then it goes back without us addressing the clearly established issue. And assume also we think the clearly established issue is wrong. That's kind of left untouched, and the case proceeds on that basis, I guess. And, there's a chance to remedy that later. But, that's just, we may not agree. Those are just hypotheticals on two issues. But if we were to, if you imagine that world, we got some inefficiency in that scenario too. Is that fair? Do you see what I'm saying?
I do. I see I'm out of time, but may I
Yeah,
respond?
go ahead and answer.
Thank you. I do agree that there would be some inefficiency there. But again, the way this sort of argument that it doesn't even apply in this post hoc kind of backdoor jurisdictional argument that really didn't make sense to begin with is a bit, I think, strained. And whether, this court doesn't have to decide that whether it applies if the issue before it is whether the regulations clearly establish the right here. And it just goes back, this court isn't making a determination one way or the other, as it's done in other cases. It's just address the narrow issue before it. And so that's what we would ask Your Honors to do, is address the narrow issue before Your Honors, and that's whether or not these regulations clearly establish the cure period for authentication purposes. And we'd ask that you reverse the judgment of the district court and enter judgment in favor of Mr. Hall.
Thank you very much.
Thank you.
We'll come down and greet counsel and proceed on the last case. I think it merits comment publicly so that you can hear that, Mr. Kardashian, I thought you did an excellent job, and you will be many times before us again and doing a good job. We'll come down and congratulate you. All right, next case we'll hear this morning, West Virginia Rivers Coalition versus Shemmer's Company. And Mr. Kadam, whenever you're ready, we'll hear from you.
Thank you, Your Honor, and may it please the Court, Alon Kedem for appellant, the Comoros Company. A preliminary injunction is an extraordinary remedy. Here, multiple overlapping errors require reversal of the injunction issued below.
Counsel, I hate to ask a question 15 seconds in, but I just
Please.
want to clear two issues off the table to see if they're here. And then you can go to the arguments. I didn't see these in the briefs. Is there any question, or did your client make the argument below that a private suit was improper because the government was diligently prosecuting the permit violations?
I don't think that argument was made.
Okay. Are there any Daubert challenges to the expert testimony that were made and preserved below?
None that have been raised on appeal.
Okay. Thank you. Go ahead.
Among the overlapping errors, plaintiff's sole identified member, Ms. Robinson, stopped drinking the effective water years before the alleged violations and has disclaimed any intention to resume, regardless of what happens to the violations. The district court presumed irreparable harm and did so primarily based on supposed harm to the public. The court also confused the substance at issue, HFPO-DA, or dimer acid, with a far different substance, PFOA, which is not at issue. And all sides agree that the permits were issued in order to protect human health by keeping concentrations of dimer acid below 140 parts per trillion, a level that has never been exceeded, not even once. Because plaintiffs have not established irreparable harm or even standing, this court should vacate the injunction, sending it back so that EPA can address any remaining compliance issues in the first instance through an administrative process that is already well underway.
Do we have to decide, do we have to talk about standing first? That sounds like a silly question. You always have to talk about standing first. But this is on an appeal from a preliminary injunction. And my understanding is that the plaintiffs have changed since the preliminary injunction. There's a new plaintiff has been allowed to intervene, things like that. So there's kind of a separate question of whether there's jurisdiction over the lawsuit, which is not really the question before us, whether we have jurisdiction or the district court does, but instead the predictive question of, for a preliminary injunction, at that time, did the district court have reason, did it seem likely that this particular individual would have standing? Is that jurisdictional, or does that just go to whether the injunction, whether the court was justified in granting the injunction?
So I think there are some overlapping issues. The basis both of standing for the sole plaintiff in whose behalf the injunction was issued was Ms. Robinson. We can talk about her. And also, irreparable harm supposedly to Mrs. Robinson was part of the analysis.
Right, and our irreparable harm analysis has to look only at her because these other plaintiffs or other newly named individuals were not part of that analysis.
That is not the basis of the injunction that's before you on
Right.
appeal. That's correct.
But for standing, we just have to be satisfied that, like, now we have jurisdiction. Not necessarily, do we have to be satisfied that Mrs. Robinson had standing at a particular moment in time?
I think you do, because relief has to be granted on the basis of standing. Standing has to exist at the time that a court issues relief.
Right.
And so if there was no standing because Ms. Robinson didn't have standing at the time, the fact that they've now introduced some other member who, we don't accept that these new members might have standing on their own right, but even assuming that they did, it would still not be a basis for having granted the injunction that's in front of you.
But if it was just a standing issue, we'd send it back for the judge to then say, well, these other individuals have standing and I'm reimposing the injunction. I mean, seems like we should address the merits of the injunction.
So I think there is very much that concern that if you just threw it out on standing basis without saying whether it would have satisfied irreparable harm, that the district court might go ahead and impose the same injunction, which would obviously lead us into the same predicament that we're at this point. So starting with standing, Ms. Robinson made clear that she stopped drinking the affected water years before the permit violations that are alleged to provide the basis for this injunction. She was also asked repeatedly whether she would go back to drinking the water, assuming that the permit violations stopped, and made very clear that she wouldn't. And I think it's useful to sort of provide the framework that the Supreme Court and this court have followed in cases where standing is supposedly predicated on avoidance, reasonable avoidance of water or an affected area. And they always have at least three elements. First of all, you have...
Does that cover her claim for recreational use?
Yeah, so recreational use wasn't at issue in the district court's opinion, other than the sort of aesthetic value of knowing that there were permit violations.
I'm thinking in terms of standing, haven't we
Sure.
recognized that in connection with pollution cases?
Yeah, so we can talk about her sort of late-breaking argument about boating, which I think has the same feature, but it's all in the sort of nature of
You have
avoidance.
y'all both have late-breaking arguments.
Fair enough, Your
Be-
Honor.
Be a little careful.
Fair enough, I take the point. So all of these cases, you look at Laid law or this court's decision in Gas and Copper, you have, first of all, someone who regularly uses the affected area or the affected water, often daily. Then you have essentially a clean break where they stop doing so, and they say the reason that I stopped is because of the violations. And then third, there's a declared intention and a plan to go back to using it after the violations stopped. With Ms. Robinson, you have none of those. She wasn't drinking the water, rather.
But why don't you
Sure.
focus on Judge Niemeyer's
Sure.
question about the
About
boating?
boating,
That may be,
Sure. So.
I don't mean to say they don't have other arguments.
No,
but-
understood. And just one point about boating before I get into the reasons why it's deficient. That wasn't part of the irreparable harm finding from the district court, so it wouldn't
Stay
support.
away from the irreparable harm.
Sure.
I may be wrong on this, but I'm treating standing,
Yeah,
which is sort of a person, whether he's in the right position to make a claim.
right,
As opposed to the necessity for
Understood.
an interim injunction.
sure. So with respect to boating, we don't have any of the three features I just identified. She didn't claim that she did it regularly. She was equivocal about how many times she did it. It sort of seemed from her deposition testimony that maybe it was one time. She said there was someone driving the boat, I think. When she was asked when it happened, she couldn't remember whether it was in the last 10 years. She couldn't remember whether it was before 2011. That's at page 1582 of the joint appendix. So that strongly suggests that she had stopped at some time well before the alleged permit violations. She also didn't say that the reason she stopped is because of discharges of HFPODA specifically. She just said, because the river is polluted. And in fact, when she was asked the last time she used it, she said, I know that there was C8 in the river. C8 is a reference to the other chemical, PFOA, which she, in her declaration, attributes to the cause of her preeclampsia. And so I think all of this raises a strong inference. Number one, she wasn't using it regularly for boating. Number two, there's no allegation that she specifically stopped because of these permit
Does it
violations.
really have to be regularly? I mean, there may, obviously, you have a case like the Laidlaw where there is more regular use, and comparing it to that, it's sure less. I'm not disagreeing with you there, but a little bit of standing is all it takes, right? So, I mean, it seems that we got to be a little careful. I mean, I think we need to know it is concrete enough. So I appreciate your talk. I think those points are fair, but the fact that it's not as regular isn't necessarily determinative, is it?
Well, let me put it in sort of broader context. Laidlaw was itself an innovation in the law. There was the dissent by Justice Scalia who said, you're going to make it trivially easy because you're just going to have people who say, I use the affected area regularly and I would go back to doing it. This court in Gaston Copper assimilated Laidlaw in a case where there was also essentially daily use. So there was someone, Mr. Shealy, whose pond had been polluted by the affected water, and he said, I fish in it, and I fish in it regularly, I go swimming regularly, and my kids use it during the summer essentially every day. He also said that his property values were directly being affected. So, and even in that case, there were some concurrences that said, look, we have to follow what the Supreme Court has said, but we think that this is lowering the standing bar well below what it used to be. So I think that there's a good
Well,
reason.
it may have, but, you know.
Sure, but
we
I
may-
think, yeah, so I think even if you accept fully that the standing bar has been lowered in the respect that Laidlaw and Gaston Copper recognize, I don't think someone who at one time, she can't remember when, maybe 10 years before, possibly boated on the river, has no concrete plans to do it again, and in fact,
What about-
likely stopped for reasons unrelated,
What
that that's
about
enough to give
stepping
you
back
standing.
further? I mean, does our modern notion of injury in fact, traceability and redressability have any support at what case or controversy meant at founding?
I would say that they do, and I would point to Supreme Court decisions that talk about this and explicate it, things like the Spokio decision that talk about not just the particularity requirement, but a concreteness requirement that looks at sort of the risk to a particular person. Some of that is just case law principles, some of that is derived from the sort of case or controversy requirement we inherited from English common law. I have essentially just taken as a given that these are core requirements. That
They're
the
Supreme Court requirements, so
Sure.
that's probably a fair way to go about it.
I-
That just
yeah.
feels like,
So I think Judge Niemeyer pointed out that a question of standing is, who's the right person to bring this suit?
What
And-
about her, the inaccess to water? Is that enough to give her standing?
So I think if she would otherwise be drinking the water, that would be one thing. But she has made clear she stopped drinking the water years before the violations and has no intention to go back, regardless of what happens with it. And this is I think, the point that brings all of this together. There are a lot of people in this water district who do use the water. There may even be some who would drink the water but have stopped doing so, but for because of these violations. The fact that plaintiffs have not identified anyone in that position just underscores the weakness of their case. It's not a reason to relax the standing requirements, much less irreparable harm requirements.
Can I ask a question that may not matter as much because of other aspects of their standing? But one of the avoidance principles that the law talks about is the avoidance must be reasonable.
Correct.
And it looks like the briefing on that involves the testimony of experts. And just as a fundamental matter, does it have to? I mean, if the water, looked nasty down from, a
Right.
plant, I know this chemical, it doesn't have
different-
color or smell, but I mean, do you really need, it doesn't seem to me that you need expert testimony on that issue. So the kind of battle of experts
right.
seems unnecessary on that point.
So I think in the context of the reason you're avoiding it is because it smells bad, or it looks really gross, or it's doing something to your property values, I agree with you. You don't need an expert to say
What
that
if you
the
just
smell is
hear
bad.
there's a Clean Water Act permit and you hear it's being violated? Clean Water Act permit is, generally to protect against bad things in the water.
Right.
Why can't a person say, look, I'm just going to stay away from, I'm not going to drink it as long as I know there's, a permit violation? That seems reasonable to me.
So if a person who drinks the water would
Yeah.
only have standing if they could point to some reasonable concern about their health, it cannot be that someone can just not drink the water unreasonably and manufacture standing. That
I
just
got
can't
you.
be the case.
Fair enough.
And to your point, there's a permit violation. I think this is really important.
Yeah.
The permit issued by West Virginia was expressly based on a desire to set a level in the Ohio River for dimer acid of 140 parts per trillion. There has never been a measurement, even close to 140 parts, not in the Ohio River, not in the aquifer, and certainly not in the finished tap water, which has been filtered, multiple times. The highest finding has been 40. There has never been a finding above that in the Ohio River or downstream uses. And so insofar as we are taking the West Virginia Department of Environmental Protection as the authority on what is sufficiently safe for human health, they have said that is 140 parts per trillion.
But are we allowed to do that? Can't we take they're alleging the federal standards, right?
Right. So let me get into the federal standards, because I think that's the way that they try and bring this in. In 2024, EPA issued a maximum contaminant level goal of 10 parts per trillion. And starting in 2031, public water systems under the Safe Drinking Water Act will have to ensure that their water meets that. But what they said is, and I'm just going to read from what they said in the Federal Register. It is the daily exposure to the human population, including sensitive subgroups, that is likely to be without an appreciable risk of deleterious effects during a lifetime. So it has a couple features that are really important here. And this is important in part because plaintiff's expert was very explicit that the reason she said 10 is the limit is because of the MCLG.
It
So
would have been
number-
a great time to say Dahlberg applies here, and you have an opinion that doesn't
Right.
have any scientific basis, no testing, no peer-reviewed
Right.
literature, and then you would have had a maybe even stronger argument on that.
So I take your point. We certainly did contest the conclusion she tried to draw from the MCLG. Because number one, it says daily use. It doesn't mean one day, it means every day.
The trouble with, you contested it on its persuasiveness, and you got an opinion in there that may be not, I'm not saying it is, it may be totally valid, but if it's, got some problems, and you got two competing evidence. Now, I don't know that ultimately matters here, because on the injury, on the violation, you still have the drinking water that she's not drinking anymore.
Right.
So it may not come down, but it seems like the evidentiary posture is two expert opinions, neither of whose admissibility is challenged. And you give a district court, a lot of leeway when you're in that situation.
So respectfully, I think at the point where she says, I'm not doing my own testing, and I didn't come to 10 because I've independently determined that that's what the literature says, so much as I am resting it on the MCLG. This is what she says. One time, one day, that's what the MCLG stands for. And then later, according to the MCLG, it's one day. And so in that situation, when the MCLG on its face makes clear it's actually talking about daily use for a lifetime, which EPA defines as roughly 70 years, it is simply not credible for someone to say one sip on one day causes a significant health risk, even for someone unlike Ms. Robinson, who actually drinks the water. I see that my time has expired.
Thank you.
All right, I guess we hear first from Mr. Tini.
Good morning, Judge Niemeyer. May it please the court, counsel. My name is Derek Tini, and I appear here on behalf of the Plaintiff Appellee West Virginia Rivers Coalition. Judge Goodwin's findings on standing and irreparable harm are factual findings, as Judge Quattlebaum was alluding to. They were not clearly erroneous based on the record as a whole. He heard two disputing positions offered by experts whose qualifications were not disputed, and whose methods were not disputed.
Well, he didn't I mean, you allege standing from avoidance of the water, and your client, we're on standing,
Okay.
and before the court's order was issued, your client said that if the violations were fixed, I wouldn't drink the water. So how do we have a redressable injury?
Redressability has never required that kind of but-for analysis. There are multi-polluter cases, and even Comores acknowledges this in their brief, that when there's a multi-polluter case, that if one type of violation ceases, it's reasonable to continue to avoid because there are other violations. Although this may not be a multi-polluter case, there is record evidence, and even the standing declarant knew this. It is my understanding that PFOA and HFPODA have been released into the environment through water, soil, and air releases and deposition. So what that means is when through Comores' stacks, these chemicals are emitted. And Comores' own witnesses testified to that and the problems that they have because of stormwater, because these things are precipitating all over the community. So if you were to stop the violations at the end of the pipe, that does not render her water clean. And in this way, that's like this court's decision in NRDC versus Watkins, where this court expressly held that we don't have this kind of but-for causation or but-for redressability. In that case, there was a nuclear reactor, and it would start and stop. I'm sorry, it looked like you may have a question.
Yeah, I'm just to follow up on that. I mean, yeah, you know the record better than me, so if I get this wrong, please correct me. But accepting that, there's different ways other than the actual emission, from the outlets that would be stopped. There's still, there may be lag time from these other sources, right? But, I mean, I don't think anyone has said that, even if there are other, issues with the emissions, if the permit violations, so as I was saying that, I'm correcting myself. You're saying that there are, the water can be polluted by things that were not permit violations?
Yes, Your Honor, I am.
And you're saying that we can enjoin a permit violation if the violation of the permit is not redressable, if something that's not the violation of the permit would cause someone to not drink the water?
Look, yes, we are, and here's why. And I think that the Massachusetts versus Environmental Protection Act case that the Supreme Court decided what makes this clear. Redressability never has to be a silver bullet. That case, Massachusetts versus EPA, involved climate change and a specific issue about the regulation of vehicle tailpipes. I don't think there's any dispute, no matter which side of the climate change, debate you may be on, that regulating tailpipes is, not going to solve global warming. And so if the injury is a potential global warming and doing nothing about the tailpipes isn't going to solve global warming, well, then how is that redressable?
But you're talking about an avoidance type of standing. I mean,
Yes.
doesn't it depend on the type of standing you assert when we're looking at that?
I don't think so. I think that avoidance is a type of injury. And let me take a step back, because I think this focus on the drinking does ignore the fact that she is exposed to this water daily when she takes a hot shower.
Which your expert said she could not say would cause any harm.
Well, she said that when she was first asked without the declaration in her hand, but that gets cleared up on cross-examination. And in the
Assume I don't think, do you have any basis for that other than your expert's testimony? Because I've read the testimony, I've looked at it, and I'd love to hear your thoughts. I'm not trying to cut you off, but do you have anything besides Schlesinger on that? Because I thought she was pretty clearly did not support that, an expert standard for that theory.
She is later asked by the court directly whether this individual who has previous C8 exposure, and that is a big part of Dr. Schlesinger's conclusion, is because she's carrying a body burden because, you might think of her as an eggshell plaintiff. And so therefore, because of those circumstances and the fact that she lives there, she said unequivocally, and this isn't challenged on their brief, that it is harmful for Ms. Robinson to have even a single exposure over 10 parts per trillion. And that's,
I was pretty sure, I'll look back and, yeah, that's a factual matter as to what's said. I understand, if that's your argument, I'll double check that. I thought that the district court went in and said, does this change, if, she says she stopped drinking the water or something to that effect, and she says, I haven't considered it with that in mind.
so that comes before this later interruption by the court. At page 1341 is the
I'll look
dialogue
at it.
I was talking about.
Keep going, I'll look at that.
Sure. Before that, yes, she did say, I cannot come to a conclusion. But then defense counsel put Ms. Robinson's declaration in her hand, allowed her to review it, and then she came to that conclusion. What you're witnessing in the transcript is her refreshing her recollection of the circumstances that she could not draw a conclusion on in the immediate colloquy with the judge. But in response to a later colloquy with the judge, she says unequivocally that there would be harm. And that is the type of, because that's supported by the record, that's the type of factual finding that would have to strike this court as wrong with the force of a 5-day-old refrigerated dead
1341?
fish. Yes, ma'am. Yes, ma'am,
You might
1341.
want to check that when you come up on rebuttal.
Oh, okay, well, I'll look at it right now. I apologize. I want to make sure I get that right.
I mean, I don't want to take your time here, but.
No, I wouldn't come up on cross with any other number. This starts with, okay, so the court starts at line 8, but, and I'm going to quit, but taking this particular lady, Ms. Robinson, who, as you say, lived there and had blood levels from the C8 studies, is an exposure that's measurable and exceeds 10 parts per trillion, I forget what my question is, harmful? Yes. And that follows that interchange where the judge asks her specifically, and that would be at page 1333, where she says, in response, I cannot come to a conclusion based, because I don't know what the contribution of brushing her teeth, what the relative would. She didn't have the declaration in her hand, she's given it.
You're saying 1341 is specific to not drinking, just bathing and brushing teeth and watering vegetables.
I think that has to be what he means by this particular lady, because it's clear the court understands that she has avoided drinking and is only brushing her teeth and bathing and washing her dishes in this toxic stuff.
To be fair, the witness didn't seem to know that until the court asked it previously. But the page before it, the witness clarifies she's testifying about PFOA and dimer acid together, right?
Yes, but when the judge asks about 10 parts per trillion,
Right.
that is HFPODA specific. PFOA is a different standard. That would be 4 parts per trillion. So the judge, who is there watching all of this in real time, and I think she did realize she didn't, she only brushed her teeth, but it's important, the court is the one whose knowledge is important, right? Because it's his factual finding. When he asked this question about the particular lady, he knows that she brushes her teeth and showers, but has avoided drinking it because of Kimura's discharges. So he knows all of that, asks her specifically about it, and the witness says yes. And so for that reason, I think that there is clear exposure and evidence to support the factual finding that there is harm here, based on.
What if that, assume it says what you say, I hope that doesn't come across like I don't believe you.
But it does not, Your Honor.
So just
My dad's
for
from
the-
Missouri, so I understand the show me part.
For the sake of discussion, that's correct. But we can look on and we were to look at this record and, come to the conclusion that as a matter of law, that's an inadmissible expert testimony. That's a big assumption too. Can we do that?
I don't believe that's within the standard of review that this court applies on preliminary injunctions, because you're going to have to assume a whole lot of things before you get there that the court never decided. For example, does Daubert apply in a preliminary injunction standard? I mean, it may feel like it absolutely does, but this court's case in Grimm and the Supreme Court case in Texas versus Kamenich suggests that there's a looser standard at preliminary
Yeah,
injunction.
all those cases really talk about affidavits. There's not hardly anything that talks about that would apply to expert witnesses.
Well, at the appellate court level, that is correct, but there are district courts who have taken that to conclude that Daubert doesn't apply.
I won't be on the Daubert side issue anymore.
Well,
but
you're welcome to be on whichever issue you would like, Your Honor.
Can I ask you a little bit more about Schlesinger? Because she also said she couldn't quantify the increased risk. So she's asked questions and says, yes, it would be harmful. One exposure would be harmful. But then when asked, well, what's the harm? What's the increased harm? She says, it's a risk. And I said, well, what is the risk? And she says, she can't say how much the risk is. So is that, I mean, when we're talking about irreparable harm, how does that factor into your argument on irreparable harm?
This is not, I would not try to defend a risk of risk case. What she is saying is, I cannot quantify the actual harm that is occurring, which this court has recognized exposure as a harm in the Somerville case just last year. Somerville versus Union Carbide Corporation. I cannot quantify it because I don't have the tools to look molecularly to understand. She does know, I'm sorry.
Oh, yeah, I just, you might, in each case, whether exposure is a harm, that's a big statement that is kind of a case-by-case analysis, right? Like,
Sure.
to say exposure is a harm in every case would be to say the risk that something might happen from the exposure is the harm, and that can't be right.
Well, fortunately, we don't have this case. Dr. Schlesinger testified, and pardon me for getting into the weeds, but she testified about PPAR alpha. That is a receptor that is activated by this. And once that receptor is activated, the liver starts to make fat. And it only becomes perceptible or diagnosable as fatty liver at some other level. But each exposure to HFPODA at greater than 10 parts per trillion causes that imperceptible or microscopic injury. It is an exposure with an actual harm inside the body. It's a bodily invasion that leaves a mark. Is it quantifiable or calculable? No, but it doesn't have to be irreparable harm.
Let me ask you, what, the injunction enjoins Chimers from violating the law. The law is emitting these toxics above the permitted level. What do you anticipate they would have to do?
Well, the record supports that what they had done in
I'm
immediate.
talking about the injunction language.
Yes, well,
The injunction language is just a generalized saying, comply with the law. And so they have done that, they have exceeded the emissions, and they're now in an agency proceeding to adjudicate that or adjust that.
and the judge heard all of those facts.
I'm
and
not talking about, I'm asking you.
Yes.
What do you interpret that injunction to require them to do?
It is not an obey the law injunction. And
Pardon me?
it is not an obey the law injunction. That's not the basis of
What's
their
the
challenge
language?
here.
What's
The
the-
language is, you shall stop your discharges that violate this permit in any means necessary. And the record here reflects the means. This got in before the injunction was issued, okay?
Now, I want to stick with that, I want to stick with the language of the injunction.
Yes, sir.
I want to understand what you think the defendant has to do.
What I think the defendant has to do is what they actually did and are in compliance. They submitted, before the court issued the injunction, evidence that they had reduced their discharges by collecting various other sources of water and keeping them from going into the Ohio. So they were able to come into compliance. I believe, I'll proffer to the court that they're in compliance today, and they've not reduced production at all. So what the injunction led them to
They're in
do,
compliance today?
as a result of the injunction, yes, they are. They have complied with the injunction. We have no qualm with their compliance. We aren't on a contempt proceeding. The court issued the injunction. They've been in compliance. But the compliance resulted as a result of this lawsuit, and they started treating additional waste streams. And that's, I wish I could remember the record number, but the court put, the Comores put that in the record. They put it before the court that they were treating air conditioner condensate that they had been dumping into the river. Because this stuff's in the air, there was a lot of it in the condensate. They stopped putting that in the river, and they have found a way to come into compliance. So I don't have to think about what it would take to come into compliance. We have the defendant's own explanation in the record before the injunction was issued.
What's the status of the agency proceeding?
The status of the...
How would the injunction affect that?
The injunction does not affect EPA's ability to bring them into compliance. Now, Congress, first of all, this is not a preclusive action that EPA is taking. Comores never raised that issue because it would not succeed on the merits. Congress gave ways for agencies to preclude citizen suits, and the agency never took advantage of them. But regardless, they can comply both with Judge Goodwin's order and with whatever the agency ultimately decides. That is still in a state of back and forth on approvals of what they're going to do. But what Judge Goodwin clearly said was this community cannot wait for the bureaucrats to work out the solution. I am a federal judge. I see a violation of law. I see a concrete injury.
Exactly what the problem, I think, with his injunction is, as alleged by the appellants. In other words, he started with the fact that a permit was being violated, and therefore it has to be enjoined. And that there's necessary damage as a result. I mean, he talks about the whole community, he talks about the whole area, he talks about the environmental laws, he criticizes winter, which is very strange, because the injunction is a very preliminary, before trial remedy, and it's an extraordinary remedy. And so winter requires a high level of compliance, and yet the judge sort of gave it the back of the hand. He said, how can you have a violation of law and not an injunction? And so he talks about downstream, he talks about Kentucky, he talks about all these other things, instead of focusing on the irreparable harm to Ms. Robinson.
Your Honor, I don't think that's a fair reading, and here's why. He editorializes about winter. There is no way for me to...
I'm talking about how he treated
and then he says...
talked about violations of the law, there's got to be injury.
That's not, on JA 1625, the judge expressly said that wasn't what he was doing. His irreparable harm analysis does not rely solely on permit violations. He disclaimed that. I see that my time has ended. Can I finish my response?
Sure.
So yes, at 1625, he disclaims that whole premise. And then he goes on to make specific factual findings about harm to Charlize Robinson and the plaintiff. So his statements about harm to the public, about Kentucky, whatever one may think of those in compliance with winter, that's harmless error because he complied with winter in finding harm to this plaintiff based on the testimony that he heard live. Thank you, Your Honors.
Yeah. All right. Mr. Newman, do we hear from you?
Justin Newman for Plaintiff Applee Little Hocking, we're the intervener that Judge Rushing talked about. And I wanted to make a couple of points. One, that Little Hocking, we are a Ohio water provider that was granted intervention in this case. We provide water to 12,000 people in Ohio. We sit directly across the Ohio River, about 1,300 feet from the Washington Works plant. And our production wells on the Ohio side of the river are designed to draw water in from the Ohio River. So below, we were one of the, we were granted intervention because, and the judge found that we had Article 3 standing because our water, as a result of these dimer acid violations, 2018, dimer acid was first discovered in our water at a level of 32 parts per trillion.
Can you just remind me, were you granted intervention after this injunction was granted?
We were granted intervention before the injunction was granted, but after the hearing.
After the hearing?
Yes.
Do
Okay.
you have, what is your relationship to the injunction? Are you a party?
We are a full party to the case,
No,
yes.
to the injunction. We're
We-
here on a preliminary injunction.
Are we a beneficiary of the
Yeah.
injunction?
I've-
We are,
It doesn't address you, does it?
well, it does address us in one sense. One, that we are one of the downstream users who is suffering from increased dimer acid concentrations, and I think it would be fair to consider us under the Amico case. And in fact, we've heard a statement today that was quite surprising, that there was no, that the permit was set in order to make sure that the Ohio River water never got above 140, and that no downstream water supply was ever above 140. Little Hocking, again, right across the river from Comores, started out at 32 parts per trillion, and we're now at 870 parts per trillion. That was one of the reasons why we were granted intervention in this case. And so I think you can look at us for two reasons. One, we clearly have standing as an intervener, and we'll be able to prosecute the case regardless to completion. And then I also think under Amico, we're an example of environmental injury that is well above this 140 parts per trillion number that Comores has said.
But we, I mean, it sounds, I mean, we have an injunction order that's been appealed that relies on for standing and irreparable harm totally on Ms. Robinson, correct?
I think that is true on standing, not true on irreparable harm. I think the judge considered downstream water
Well, he
users.
considered a lot of things. I mean, Kentucky, he considered the whole area.
Well, he considered.
But he didn't particularly consider you as a party to the injunction, I didn't think.
He did consider downstream water supplies, and we are the most contaminated. Louisville's another one, Cincinnati is another one. And I do think that we are properly considered under the Amico case, which is looking at environmental injury and the mother lode of contamination that is in our aquifer as a result of these discharges is
Yeah,
certainly.
and you may be able to make that, maybe we think that's enough to be considered here. Maybe that
Sure.
is something that you should make in your own injunction motion, and we'll have to consider that.
And I hear that, and I do want to say that I just don't want the record to be reflect that the maximum, that there's no water supply that's been affected over 140 parts per trillion, because that's just not true. We're
All right.
over 5 times that. So, thank you.
Thank you. All right, Mr. Caden.
Thank you, Your Honor. Just to make 4 quick points, starting with the representations my friend made about the record with respect to her toothbrushing. So on page 1341, he points out that the court asks about exposure, and the witness says, yes, there is harm. And he infers from that that this is a revision to the expert's statement about 10 pages earlier, where she was asked about harm from toothbrushing and said, I can't come to any conclusion. With respect, that's not a plausible read of the record. If you look at the immediately preceding page, the court asks, there's no safe amount of alcohol that you can consume, right? The witness says yes. Is there a safe amount that is harmless of PFOA that you can consume? The witness talks about that. She says, are you asking about PFOA or HFPO-DA? The court, both. Yes, there is a safe level. So that is the immediately preceding discussion. It makes crystal clear they're talking about consumption, which was overwhelmingly the focus, presumably because the witness herself couldn't come to any conclusions about, brushing teeth or taking a bath. The second point, my friend argues that there's no but-for standard of causation for cases involving multi-polluter cases. But then in his next breath, he admits this is not a multi-polluter case. So that really doesn't help him whatsoever. He brings up the Watkins case, and there, I think it actually strongly supports our argument. In the Watkins case, you had an avoidance case based on the same 3 factors that I referred you to earlier. You had someone who was using the affected water. In the case of One-Affiant, it was daily. They immediately stopped because of the violations, and they had a specific plan to go back. The district court then said, well, you haven't gone back. The plant has been shut down for 2 years. Doesn't that undermine your argument? And this court said two things. First and foremost, it said, well, it is undisputed, there's undisputed evidence that the damage caused by the violations persists for years. So we can't draw any negative inference from the fact that these people haven't gone back to it. And then second, it made some statements about causation, which were arguably dicta. But you still had the first two aspects of the standard that I talked about. You still had regular use leading up to the violations, and you still had someone who stopped because of the violations, immediately because of the violations, and attributed the change in behavior to the violations. We don't have either of those here. Ms. Robinson has said, point blank, I stopped in 2018, years before the violations. She has also said, I will not go back regardless of what happens to the violations. And contrary to my friend, she never said it's because of some sort of concept of a lag time. There is no evidence about a lag time that would affect her here. She's never claimed that the reason I'm going to stop indefinitely drinking the water is because there is a lag time between the violations.
It sounded to me like the argument was not just that there's a lag time. It was not really that there's a lag time in the violations and the ability to drink water.
Right.
It was that there was some other pollution that didn't come from a violation of the permit that might have affected a decision to drink water.
That's right.
And-
And I think that shows fairly clearly, number one, there's no causal connection between the violations and her change in behavior. And number two, there's no redressability because no matter what happens with the violations, she's still not going back, not because of dimer acid, but because of a different chemical, PFOA. To your point, Judge Niemeyer, I think it is deeply troubling what the district court said about presuming irreparable harm and the fact that he based the injunction primarily on supposed irreparable harm to the public. And even if you disagreed with us about everything else, if you agree with us on this point, it still requires vacating the injunction because an injunction is supposed to be an exercise of discretion and a balancing of factors, and the district court put something on the balance that is plainly inappropriate. Finally, on the question.
Well, it's in a bigger picture, and both parties seem to recognize this, is that a preliminary injunction is a temporary order to preserve things or mandate certain conduct temporarily on a strong showing pending trial. And the question is there anything that needs to be done here before trial based on the circumstances of Ms. Robinson?
Right. And based on the circumstances of Ms. Robinson, who's not affected in any way, we would posit the answer is no. Talking more generally about the public. First of all, EPA and West Virginia have all sorts of emergency authorities that they could use and could have used if they thought it was merited. Instead, and if I could just finish this point, instead, they've been engaging since before the suit. I'm sorry, I think, yes, actually, before the suit, certainly before the injunction, they've been engaging on an administrative order on consent process through which Chemours is making all sorts of adjustments. They are also undergoing a new permitting process that will include standards that are at least as stringent. That is the normal way Clean Water Act violations are supposed to be addressed.
So why then is there, and I know we're over time, I probably shouldn't raise this, but I was intrigued by the first question I asked about the diligent prosecution issue. Does that apply here? Or, I mean, I know you said you didn't make that argument. I'm not going to decide something, but I just I'm surprised, given what you just said, that
Sure.
that's not something that is in this case.
Yeah, so I think what we would say is the Clean Water Act does not displace the normal winter standards for when an extraordinary remedy of a preliminary injunction should issue in an unusual case. But what the Supreme Court said in the Weinberger case is the provision, meaning the Clean Water Act, makes clear Congress did not anticipate that all discharges would be immediately enjoined. Consistent with this view, the administrative practice has not been to request immediate cessation orders. Rather, enforcement actions typically result, by consent or otherwise, in a remedial order setting out a detailed schedule of compliance designed to cure the identified violation. So that is the sort of normal way the process is supposed to play out, absent some extraordinary circumstances, which are certainly not present here.
Thank you. All right, we'll come down and greet counsel and adjourn court for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Long day.